Hi, welcome to my channel and please don't forget to like, comment and subscribe. Today I bring a topic about the use of force in the course of maritime law enforcement operation. Naval forces are increasingly involved in missions other than war, which entail non-traditional military tasks and mostly resemble operations conducted by domestic law enforcement agencies on land. Examples of these missions include anti-piracy, anti-terrorism, anti-marine pollution, and anti-narcotics operations. They fight against the smuggling of migrants and the trafficking of human beings, the protection of fisheries against illicit exploitation, and the protection of oil or gas platforms from activists. Scholars and practitioners commonly call these kinds of mission maritime law enforcement or MLE. MLE is a catch-all concept indicating all police-type operation conducted by warships and other state-owned vessels against criminal or otherwise prohibited activities at sea. On the whole, MLE implies the interception of merchant vessels with the purpose of a sub-injection or subjecting them to the control of the intercepting vessel's flag states, and also possibly imposing criminal or administrative sanctions. This growing trend towards MLE is usually coupled with the attempt by coastal states to advance their jurisdictions towards international borders for both political and economic reasons. Indeed, by acting in areas well beyond their territorial borders, states aim to achieve three objectives in particular. The first is A. Anticipating their response against potential security threats, and then B is giving substance to their claims over such areas, and C. Defending or controlling their political and economic interests against any external interference. International borders have therefore become the principal stage of MLE operation. At the same time, due to their unique capacity to project naval forces far from the coast and for a long period of time, navies have come to be the key of actors in MLE. In this framework, because MLE operations are police-type operations, the level of force that warship may lawfully employ during the interceptions of a merchant or private vessels should in principle be tied to the rules governing the use of force by a domestic police on land. However, both the scenario and the kind of the weapons or means of coercion used by warships are totally different from those of an ordinary police action on land. The 1982 United Nations Convention on the Law of the Sea, or UNCLOS, does not contain clear rules on the use of forces in the MLE. This gap was partially filled in 1999 when the International Tribunal for the Law of the Sea, or ITLOS, established a set of principles and rules on the use of coercion in MLE operations. Whereas the ITLOS principles may currently be regarded as the primary international maritime law rules on the use of force in MLE, consideration needs to be given to the way in which states have applied such principle in practice. According to their constitutional and domestic criminal or administrative law. Indeed, Since MLE in international waters may be considered first and foremost a national activity, also when exercised in the framework of a multinational operation carried out outside the state's territory, warships end up applying extraterritorially domestic law rules. The latter may be more restrictive than those developed by ITLOS, or in any case are the result of a particular interpretation of international principles and rules by a domestic courts. This is why states still retain a primary role in MLE, and any legal analysis should not avoid considering, first of all, the domestic law of all the states concerned, i.e., both the intercepting and the intercepted vessels' flag states. And then, nevertheless, the use of force by warships in MLE should also respect the aforementioned international law principle and rules, so that it becomes essential for any interpreter concerned with the legal framework of today's peacetime naval operations to clarify the scope and contents of such principles and rules. In addition, defining standard principles and rules may in turn facilitate the interoperability of multinational forces, which are increasingly the main actors of current military operations at sea. This is therefore aims to show how international law principle and rules gathered from international time, also international convention and case law from international courts and tribunals may be applied in the practice of law enforcement operation at sea, and how or to what extent the use of force in MLE may reflect a legitimate balance between the respect of international maritime and human rights law on the one hand, and the repression of crimes including transnational crimes or other illicit activity taking place at sea on the other hand. The notion of force contemplated in this article only refers to the physical coercion, also exercised by warships as part of their law enforcement duties, and does not extend to the concept of use of force in international relations. So thank you for watching, and don't forget to like, comment, and subscribe.